What trial stipulations are typical, and how do stipulations and the usual motions in limine overlap?
This is an area where it can be very beneficial to reach out to opposing counsel, even if you have struggles dealing with opposing counsel, and do it early in the trial process. Hey, rather than do 40 motions in limine, let's see if there are certain things that we can agree to. And we usually will do this in writing, meaning we'll send over a list of these are the things that we think that we can agree to. The usual trial stipulations are things like no witnesses in the courtroom until after they've testified, but for the plaintiff and the defendant. No reference to mediation, no reference to insurance, no reference to settlement talks. Those tend to be standard. Oftentimes they're recitations of the law, the usual stipulations. While it is not a requirement, usually an agreement to let the other side know 24 hours in advance which witnesses one is going to call. Sometimes people want more time for that. Having just been through a trial where the agreement was 48, I would say 24 is much easier than 48. I oftentimes don't know what's going to happen 48 hours from now in trial. Those, I would say, are generally the usual stipulations. Where they overlap with motions in limine is if you cannot reach an agreement with the defense on these, then doing them as a motion in limine to the court, saying, these are the things that we typically agree to. We attempted to work with opposing counsel on these issues. We were unable to reach agreement. We're asking the court to issue these as rulings as part of the motion in limine phase of the trial. One other piece that I think is important to address in terms of the usuals is the use of demonstratives in opening. Most opening statements are better with visuals like maps, photos, other things to help people understand what the case is going to be about. Most courts will allow that at this point. They will usually have a requirement that you show your demonstratives to the other side, and if the other side has an objection, to alert the court so the court can make a ruling. Sometimes opposing counsel will agree to using demonstratives in opening, and that's where it overlaps in terms of usual motions in limine. Hopefully this has been helpful for folks, and particularly if you're getting ready for trial. If there are questions that you have on this or other areas, we'd be happy to address them. Hit us at podcast@coopers.law with any questions, comments, feedback you might have for the show. If you found this helpful, we would love your 5-star review, and we'd love for you to share this with anyone who you think might find it beneficial, particularly folks who are getting ready for trial. So to all of you doing justice out there, happy hunting.